Good afternoon. Welcome back to the afternoon. The pre-trial continues. Welcome.
Thank you. Good afternoon once again. Yes, we apologize for the short delay. The further directions following this morning session, when a few issues were raised, the further directions will be given by the Honorable Deputy Chief Justice and Vice President of the Supreme Court, the Honorable Lady Justice Philomena Mwiru.
With your kind indulgence, Your Ladyship, the President, Your Ladyships, and my Lords, my name is Amondi Kenneth. I do appear for Mr. Professor Wajakoya, that is a presidential aspirant in the contested presidential election, together with my...
Council, can you please take your seat? Can we read the directions first? With the issue, because Professor Wajakoya is not a petitioner, he's not a party. Can you kindly take your seat?
Most obliged.
Thank you, Judge President. These are the further directions of the court. In the course of issuing directions this morning, the 30th August 2022, on the hearing of the 2022 presidential election petitions, Council appearing for various parties made certain applications necessitating these further directions. Number one, request for additional time. The request for additional time by Council for the first, second, and the 9th respondents of above the time allocated and issued earlier this morning is hereby declined. Direction number 2, representation of the IEBC. After the various petitions were filed and served on the IEBC, and the chairman of the IEBC, Wafula Chebukati, appointed counsel to represent him. The law firms went on record and filed their responses respectively. At the same time, the 4 commissioners, namely Juliana Sherere, Vice Chairperson, Francis Wandera, Justus Nyangaya, and Irene Masit, were named as respondents in various petitions individually, and they retained their respective counsel, and they filed. On the 27th of August 2022, the firm of Issa and Company Advocates lodged a notice of appointment of advocates that is dated the 26th August 2022, purporting to act for the IEBC. At the pre-trial conference this morning, the issue of the legal representation arose. The IEBC, through the firm of Iseme Maema and Kamau Advocates, filed an application on the 29th of August 2022, seeking to strike out the notice of appointment and all pleadings by Issa and Company Advocates. The motion was supported by an affidavit filed and deponed to by Marjan Hussein Marjan, the Secretary and Chief Executive Officer of the IEBC. We have now been called upon to give directions and to resolve the question of legal representation of the IEBC. We have considered the pleadings, the record, and the brief statements by counsel. It's our considered view that this court cannot deal with the issue or any dispute as to the legal representation of the IEBC as an institution in these petitions. It is not the business of the court to determine who represents the IEBC in whichever formation. There is an internal issue which must be resolved by the IEBC, its commissioners, and other internal organs. This court will not be drawn to this dispute in these circumstances. As a result, the application to strike out the notice of appointment and pleadings we've considered these arguments, and as a result, we allow the application dated the 29th August 2022. That is to say, the notice of appointment filed by ISA and company advocates is struck out. The four commissioners are at liberty to deploy and utilize the services of Senior Counsel Paul Muite and Isa Mansour advocate in these proceedings. Direction number 3, pleadings filed out of time. As regards whether or due to late service, on account of the dictates of Article 14, in respect of access to justice, national importance nature of the presidential election petition, we direct that all pleadings that were filed out of time, including those that were filed by 2 p.m. today, be and are hereby deemed to have been filed in time. The parties against whom such filings are made, but rather shall be at liberty to respond thereto by way of oral submission at all times upon consideration of the issues therein raised, expunged from the record of the court or have the effect of mutating the original petitions. Number 4, scrutiny. We direct the Inspector General of Police, in liaison with the Registrar of this court, to provide adequate security during the exercise of scrutiny. Direction number 5, additional counsel. Excuse me. The number of counsel permitted in the courtroom beginning tomorrow remains as directed by this court this morning and shall be firmly enforced. Direction number 6, further affidavit. Learned counsel for the first respondent, the Honorable William Samoei Ruto, has informally applied for leave to respond to 2 affidavits presented by the Attorney General in petition number E007 of 2022. With effect from today, the 30th day of August 2022, 2 p.m., as indicated in paragraph 3 above, the court will not entertain any further lodgement of pleadings. However, Council is granted leave to respond to the two affidavits that were presented by way of oral submissions at the hearing. Direction number 7, amici applications to participate in scrutiny. Mr. Charles Kanjama, Senior Counsel, Counsel for the amici, John Wal, Dr. John Sevilla, and Martin Mirero, has made an application to participate in the scrutiny exercise ordered by this court in a ruling delivered today, the 30th of August 2022. He now wishes to make a report on his amicus brief, which is already rightly. We will omit that bit. This is the direction. The role of the amici ought to the written brief, that's common knowledge. Indeed, when we admitted Mr. Kanjama's client in this matter, we specifically stated that the amici will not make oral submissions and shall rely solely on their written brief. Of Francis others. Of 2015 and an amicus curiae shall application to address this particular and they are signed by the 7 of us. Thank you, Judge President.
Thank you. Those are the directions. We have a long journey ahead of us. We have to prepare for tomorrow, but for the sake of the advocates, to speak about his client, Professor Wanjakoya, just to remind him that we do not have a petition under Article 140 challenging the election of the president-elect. We also do not have an application seeking to join the direction across the proceeding. Ruling where a similar candidate, the Honorable Mwaure, was seeking to join, and that application was declined because we do not allow interested parties under our rules. Therefore, the lawyer, the advocates, unfortunately, you can't make an oral application at this late stage. Printings have closed, and we have to deal with the parties. Consolidate. With that, Learned Counsel.
Please, with your very, very kind permission, bring one issue to the attention of the court. We are working very hard to comply with your order for scrutiny. We know that in 2017, the court was not happy with the pace at which the commission worked. But two little issues remain for clarification so that we may expedite. Can my learned junior please do that?
Scrutiny is an ongoing exercise from this afternoon up to Thursday, so that is okay, Council.
Thank you very much, my lady. The President of the had in terms of how the orders arose, which we agreed that I will present before you for your further guidance. Court gave we would wish to get as to whether that order is to be taken to mean that is for the obvious reasons that might in relation to order number. The court did direct that we avail ballot boxes in relation to a number of polling stations. Now, reading through so we wanted to get a clarification as to whether where you indicate then it as of necessity also means and not from the polling station. My lady and my lord, is supposed after close of polling in the respective stations. It then follows that if we are to avail them, then we may need a further order that we can open those boxes and avail the specific. Finally, as part of compliance with the very strict timelines that the court has given in relation to the scrutiny, we did write to the registrar of the court so that following that order number 7, the part that says that the IBC should provide certified copies of Form 32A and 34C Book 2 to the applicants provided of and we requested that the applicants then avail those contested polling stations, possibly by close of business today, to enable us comply. But for the comfort of the court, I would want to just Council Gidmuigai did indicate, we have commenced the process of compliance, particularly with the ICT component. I'm most obliged.
With your kind permission, my ladies and my lords, was my application.
My lady, sorry for that. And in relation to the question of representation, gave the order in relation to the specific commissioners. You met Commissioner Molu. We wanted to just the court tomorrow, one for each as indicated in the order. I'm most obliged.
My Lady Chief Justice, presidential.
Address these issues, then we can come back to you. Please.
Thank you.
Please.
Thank you, Your Honor.
Mr. Otieno.
Prayer number 4 that you've granted in the morning, my lords and my ladies. In our application, we had requested for Form 34A's Book 2 of 2, but in your directions, I believe it was misspelled. It was indicated as Form 34C Book 2. So maybe when you give directions, you can clarify. So not 34.
Your Ladyship, the Chief Justice, members of this court, we wish to draw your attention to prayer number 2, where you directed that IEBC be compelled to give applicants supervised access to any servers in the National Tallying Center. We request that agents of the first and the second respondent be allowed to be present when that exercise is undertaken. That is our humble request.
Yes, may it please you, Madam Chief Justice, my lords and ladies. Just a clarification. My name is Paul Mwangi for the first and second petitioner in petition number 5. First, in respect of the orders of the court in paragraph 7, in number 7, I think the order was supposed to read from 32A. What was contested were the documents that were to be, would be a mistake. We have received a letter this afternoon from the lawyers from IEB that we have contested. They are all borne in the petition, and we shall be laying them out in a letter. To the opening of ballot boxes, I believe that would definitely be implied in the order of the court, that if the court were to ask that we gain access, that would imply a permission to open the ballot boxes. In respect of the polling stations that are turning out, that has been a common mistake. Our position should be that if it has been described to all access, and then the question would not be whether we are to obtain all the necessary access to do an audit of the information that is needed, so long as it is supervised. That is all.
Thank you. I will request your
Thank you very much, Judge President. Mr. Mwangi, indeed it is polling station. Done must begin from the polling station. So where there's a reference to Belgut polling center, it refers to the polling station. So again, that should be the reference that you're talking about. So let's follow that direction. On the question of contested polling stations, I think that's resolved. You will give the list to the registrar and to the applicants and to the IEBC by close of business today. On prayer number 7, that is a type A's and 34 A's, not 34 C's. 34 C's is what, so it's 34A.
And so we amend the direction to read that. On the server, Mr. Kilukumi, I think I don't have the orders here, but the last order allowed 2 agents from every interested party to appear at the centers, whether it is at Forodha House or at IBC, and that resolves Mr. Katwa Kigen's question on venue. I think from the orders, you can only have 2 venues, one at IBC and one at Forodha House, where the Section 12 documents are at. So I think can resolve that also. Mr. Kilukumi, you can send your agents to work with the registrar and the ICT staff of the judiciary. On the question of supervised or read-only access, the ruling was specific. It is not read-only access. It is supervised people to the servers. The IBC will understand it is supervised access, which is quite different from read-only access, which was the 2017 situation. So please allow them language. What was the other issue? 34, yes, Mr. Mwangi, it is correct. Again, the error was on the book 2, should be the book 2 of 34As, and that has a specific order as to what you do with it. Compliance is by today for the polling station that you're supposed to give. But remember also, one, the question of security, and I think that will be addressed by IBC, and that I think as Chief Justice resolves all the issues that were raised by the parties, unless I've left any. I don't think I have. I think I've addressed all, have I? Yes, I have. Thank you very much, Chief Justice.
Thank you. There was an issue being raised by Professor Wanjakoya, although I gave directions. I don't know what you wanted to tell the court.
Lady Chief Justice, members of the Supreme Court, I would like to take this opportunity by thanking you, because this is my first time to address the Supreme Court in this country, given the fact that I practice in other jurisdictions. Now, the ball of contention is, and I know, Your Honor, you have already addressed the issue. The ball of contention is, I'm a presidential candidate. I was in this room this morning. My counsels were refused to come in because we had already made a ruling apportioning the number of lawyers that were supposed to come in here, which is okay. But what I want to beg or to pray is that I pray to be given some opportunity, probably under your discretion, so that I can also be enjoined to speak through my counsel, of which I was enjoined as an interested party. I've already responses room and in the absence and Honorable Ruto, I think I'm the most approved interested parties. You should also take cognizance of injured also like to for having successfully made me to be who I am today, and my alumni, of course, the Chief Justice, that please let's look at justice to be done, even though people say or collude or speak of fairness. Fairness starts with me in this room. Thank you again.
Thank you, Professor. The fact that you are one of the presidents, we also are aware that you are an advocate. We issued directions regarding the use of this courtroom, and we explained why we only have so many lawyers allowed here. One is the space itself. Number two is the COVID protocols that require us to keep some social distancing. And number three is security. And so we have another room, High Court number 1. If you have counsel who are fully participating, can observe from the next door, and that's how it's going to go. You've had who are here who exceed the number that we gave this morning will not be allowed in this room because we want to leave this room for the purpose for which we gather tomorrow. So we thank you, Professor Ajakoya. Thank you.
And we really give you all the accolades and all Kenyans admire, many Kenyans admire you, and we believe law and Article 140 of the Constitution as a candidate. You have the first opportunity, you have a right under the law. You did not do that, Professor Wajakoyo. So with respect,
thank you very much. It's only that otherwise I would have filed, but
my brother, Justice Isouko, and Justice Ibrahim for clarifying and seeking the indulgence of Professor Wanjakoya, because we operate under the provisions of the Constitution and the rules of this court, which do not allow interested party. And indeed, if you could read the ruling we delivered this morning, Honorable Mwaure. So with those, I will beg that the court will arise. We have a very so strict a judgment on Monday. In the way we are, I believe you are doing the same.